Please.
Melissa Goodrich, defendant prosecutor.
Lauren Madison, for Mr. Slavin, who is seated to my right.
Good morning, or good afternoon, I'm sorry. This is set for like an arraignment. Have you had a chance to review the charging document with your client?
I have, Your Honor.
Do you or he wish to have its allegations formally read?
Not at this time, Your Honor.
And how does he wish to plead to those charges?
Not guilty.
Your Honor, pleas of not guilty to an aggravated child sexual abusive material possession, computer crime, distributing or promoting sexual abusive activity, a computer crime, and a possession of sexual abusive material. 6-count information. Is a forensic center referral requested?
No.
Estimated length of trial, including jury selection?
I think 2 days is accurate.
Okay. Available for a docket call the morning of March 10th?
Check my calendar, but I think the answer is yes. Yes, Your Honor.
We could do 11:10 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay, Mr. Slavin, we'll next see you with your attorney March 10th at 11:10 a.m. Okay? Did you have any other matters with me today?
No, Your Honor. Good to go.
Okay, you have a good day.
You too.
All right, next we'd have People v. Hassan Smith, file 25-6967FH. Counsel, you want to state your appearances, please?
Evening, Juliet, people.
Liz Elliott on behalf of Hassan Smith, who sits to my right.
All right, and we're here for sentencing on retail fraud first. After a delay that appears to not have met with success, have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Any additions or corrections to the information in that report?
One correction, Your Honor, the fines and costs and restitution are paid in full. Mr. Smith does have a receipt for that. Other than that, I wouldn't have any additions or corrections.
Okay. And Sheila, could you confirm that it is? Okay. All right, thank you. The advisory guidelines for 0 to 3 months. Any scoring challenges from the defense?
No, Your Honor.
Mr. Juliet, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Ms. Elliott, anything you want to say on behalf of your client?
Yes, Your Honor. Mr. Smith was placed on his delay on February 18th of 2025. He paid some of the fines and costs shortly thereafter. In March of 2025, he was arrested for an offense that was committed before this offense. He was placed on bond, and he was on bond for that offense until November of 2025. He served jail time until December of 2025, and then was placed on a 3-year term of probation for that crime out of Huron County. Both his bond and the current probation order out of Huron County prohibited him from leaving the state of Michigan. So his warrant in Maine, when he attempted to take care of that, he was told that he had to present himself to Maine to clear that up or hire local counsel, which he was, unable to do. So we're asking that Mr. Smith get the benefit of his delay, since he was largely precluded from being able to leave the state to take care of that warrant, and that the restitution was paid in full.
Mr. Smith, I don't buy that. I don't buy that at all. You could tell your probation agent, hey, I got this warrant I got to clear up, and it's required as part of my probation. You can get permission to leave the state. So that's baloney. Anything you want to tell me?
She just said I just got out on December, and it's only been 2 months, and I haven't had the money to make it out all the way to Maine. That's just it.
All right, thank you. Mr. Juliet, any recommendations from the people?
Well, I'm glad to hear that the restitution has been paid. I'm curious to know exactly when it was paid, because it wasn't paid at the time of this updated PSI. But I agree with the court that happens all the time. when somebody's on bond, and the courts actually encourage them to clear up their warrants. So I don't think he's successfully completed this delay of sentence. I would ask the court to revoke it, sentence him on the underlying charge.
All right, thank you. Mr. Smith, would you please stand for the court sentence? You did not successfully complete the delay. I specifically ordered you to clear up a pending warrant for a theft in another state. You did not do so. I don't accept the excuse today for why you didn't do so. So that's a violation of the terms of the delay. So you're not entitled to the benefit of the reduction to a misdemeanor. You're here today for sentencing on a charge of felony shoplifting for the guidelines of 0 to 3 months. And you do have prior theft history, the outstanding case in Maine, a prior conviction in 2019, and then it looks like you had some other stuff in other counties, false pretenses. You've just, got a growing theft history. Fines and costs have been paid, but we do have to enter the judgment of sentence today. So I'll assess the fines and costs of $68 state costs, $130 crime victims assessment, DNA fee of $60, court cost $350, restitution $36, $20, $40 that were previously assessed, but will indicate that those are paid in full. And I think when you come to court on a felony case and you've got warrants somewhere else and a judge says, I want you to take care of the warrants and then I'll show you leniency, and you don't take care of the warrants, then you don't get the leniency. So I am going to order you serve 2 months in the Sheboygan County Jail, credit for 2 days previously served. That's within the advisory guidelines. The sentence will be served forthwith. You can file an appeal if you wish by filing an application to the Court of Appeals. If you want a lawyer, I'd give you one, but you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that appeal process. Ask you to initial one copy. The other one's for you to fill out if you want to take an appeal.
And just like that, 2 months in jail. This is a textbook example of how judges treat broken promises in court. When leniency is offered and ignored, accountability comes fast. Let this be a reminder. Warrants aren't suggestions, they're deadlines.
I've been trying to pay my rent up to date, pay all my bills that I was late on because of that situation. And they took all my tax money from that case that I was gonna pay my restitution with.
Why did all that happen?
What do you mean?
Why did all that happen to you?
Because I
Stole. Because you stole things.
Yeah, of
Right.
course, that's
Okay.
what I mean.
All right, so it's not just happening to you.
I
These are
agree,
choices you're making,
but
and then consequences you're paying. So you're gonna go with the bailiff for 2 months
can I
jail.
say something?
You did. You're
Can I
going with the
finish?
bailiff for two months.
Your Honor, what was the jail credit?
2 days. All right, do we have Mr. Eddie Spencer? Mr. Spencer, I've got the prison for Mr. Stribick, so let's, and Mr. Keough. You ready with Mr. McLeod?
Yes, sir.
All right, let's call People v. Dustin McLeod, file 25-7066FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
William Key on behalf of Dustin McLeod.
Okay, good afternoon. We're here for a docket call and also a continuing status conference on a violation. We haven't really seen any other violations since that time. That was back in November. At this point, any objection to dismissing that pending contempt?
No objection.
I assume you have no objection to that.
No objection.
Okay, the pending contempt will be dismissed. And Mr. Keough, how are we proceeding today?
Your Honor, I do believe we are prepared to enter into a plea at this time, and I have presented the prosecutor with a signed plea agreement and the court with an advice rights.
Okay. Mr. McLeod, would you please raise your right hand for me, sir? You swear to tell the truth, the whole truth, and
Did you catch that moment? Because I stole. That's raw honesty right there. And the judge doesn't sugarcoat it. So let me ask you, where do you draw the line between hard circumstances and personal responsibility?
time to talk to Mr. Keough. You just let us know. We're happy to give you that time. Do you understand that?
Yes, sir.
All right. Now, I have to advise you the maximum penalty that you could face for the charge that you're pleading guilty to under this agreement. That'd be count 1, operating while intoxicated, third offense. That's a felony. It's punishable by a fine of $500 to $5,000 and either 1 to 5 years in prison or probation with 30 days to a year in jail, at least 48 hours to be served consecutively. 60 to 180 days community service, rehabilitative programs, cross prosecution, emergency response, and vehicle immobilization. Do you understand the maximum penalty, sir?
Yes, sir.
Are you on probation or parole?
Yes, sir.
Were you on bond for any other case at the time of this matter? Did you read and understand the rights listed on the advice of rights form that you signed? Do you have any questions for me or for Mr. Keough about any of those rights? Do you understand if you plead guilty, you'll give up those rights and won't have a trial?
Yes, sir.
And is that what you're choosing to do today?
Yes, sir.
If I accept your plea, you also give up any claim that that plea is caused by threats or by any promises beyond what's placed on the record today. Do you understand that? Also, when you plead guilty, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. But the types of issues you could raise are very limited, much more limited than if you were convicted after trial. Do you understand this? The plea agreement provides in exchange for your plea to that charge, the prosecutor will dismiss the habitual fourth notice. And there's also a sentence agreement for a county cap. Do you understand the terms of that plea agreement?
Yes, sir.
So, Mr. McLeod, that sentence agreement for the county cap is not binding on me. But if at the sentencing, I indicated that I wish to send you to the Department of Corrections, you'd be allowed an opportunity to withdraw your plea instead, not having received what you bargained for. Do you understand that?
Yes, sir.
There is an important exception to that rule. If you engaged in any misconduct between now and the sentencing by not showing up for court, absconding your bond, violating your bond, or committing a new crime, then at the sentencing, if I didn't follow the sentence agreement, you would have lost by your own misconduct the right to withdraw the plea. Do you understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in exchange for your plea?
No.
Has anybody threatened you to make you plead guilty?
No.
Is it your own free choice to do so?
Yes, it is.
Knowing all this, how do you wish to plead to the charge of operating while intoxicated, third offense? So, Mr. McLeod, back on October 18th of 2024, were you operating a motor vehicle in Sheboygan County?
Yes, sir.
And were you operating it on Galbraith Road, and you agree that's a public highway?
Yes.
Before you operated the vehicle. Now we're shifting gears. This is where things get serious. A felony OWI third offense isn't just another charge. It carries real prison time, massive fines, and long-term consequences. Watch closely here, because every answer from this point forward matters.
Do you remember the results of that test?
It was a 1, 4, 3.
Okay, and you agree that that's above the legal limit of 08? And at the time of that incident, did you have a prior conviction for operating while intoxicated out of the year 2000 in the 63-2 District Court?
Yes, sir.
And from the year 1999 in the 89th District Court?
Yes, sir.
And Mr. Keough, you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
Mr. Keough, are you aware of any other premises, threats, or inducements?
No, Your Honor.
Ms. Goodrich?
No.
And Mr. Keough, in your judgment, has the court fully complied with the requirements of MCR 6.302?
It has.
Ms. Goodrich?
Yes, Your Honor.
Mr. McLeod, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you are guilty of that offense. So I hereby accept your plea. Mr. Keough, we could schedule sentencing for March 17. Are you available by any chance that morning?
I'm actually not, Judge. I've got a conflict in Mackinac in the morning and Charlotte in the afternoon.
Okay. Let's see, I mean, this incident occurred some time ago. We haven't had any recent bond issues. Any objection if I put it out to the tail end of April? You
No,
available?
that's fine, Judge. That'll be fine.
Okay, April 28, you available?
Yes.
Then let's do April 28 at 1:30 in the afternoon. And
One
Ms.
more
Good,
time with the time on that, Judge.
1:30.
Very good. Thank you.
And Ms. Goodrich, I assume no objection to continuing bond?
No objection.
Okay, bond will be continued. Mr. McLeod, your sentencing is going to be put out to April 28 at 1:30 in the afternoon here in the courtroom. And you have to cooperate with a pre-sentence report. So stop by the probation department and schedule an interview so that they can write a report so I know more what's going on in your life these days, so that we can come up with a sentence that's appropriate. All right, any questions for me, sir? Okay, we'll see you then.
Thank you very much, Your Honor.
All right, thank you. Do you have anything else with me today, Mr. Keough?
I do have Mr. Walty, but he's incarcerated.
Mr. Who?
Walty.
Walden? Okay, let's bring him up here.